Hello and welcome to FFRF's Ask an Atheist. I'm Liz Cavell, Deputy Legal Director here at the Freedom from Religion Foundation. I am joined today by Chris Line. Another attorney here at FFRF, and we are covering the first two Supreme Court decisions that we've gotten this term on the religion clauses. So it is decision season. The Supreme Court is still handing down decisions as we speak, but we've gotten two so far of the ones we're watching. So we thought that's kind of a lot to break down. So we'll cover these two cases first, and then as the season continues, we will cover just the other decisions that we learn about as they come.
Yeah, so there's three more we're still watching that we'll cover in another one. Those three actually are a little bit less tied directly to our issues. The two that we have that we're going to talk about today are both cases that are directly related to our work. We're
going to start with the good news, I guess, the less bad news, as it usually goes in the Supreme Court decision season. So already in late May, which is pretty early by Supreme Court decision standards, they release decisions all the way through June, often into the first week of July. But in May, late May, the Supreme Court handed down their deadlocked 4-4 decision on a case involving the nation's, what would have been the nation's first religious public charter school. So just to back up, we've talked about this case before, but this was a case coming out of Oklahoma. It was the Oklahoma State Charter School Board versus Drummond. The actual state AG was on the other side of this case. This case involved what would have been the proposed first Catholic charter school. The school would have been St. Isidore of Seville, I think. The case went up to the Oklahoma Supreme Court, which held that state law and the state constitution prohibited religious public charter schools, that charter schools under Oklahoma state law are public schools, and as such cannot be religious. And so the denial of a public charter to St. Isidore's Catholic virtual school did not violate their constitutional rights. In fact, it was compelled by the state's Establishment Clause. So the Supreme Court snatched that case out of the jaws of federalism. Even though that was a question of state law, the Supreme Court accepted it in order to review whether or not that decision violated the federal free exercise rights of the Catholic school to, be given sort of equal access to a public charter without religious discrimination. So, it basically was trying to extend the holding that we've seen in cases like Carson versus Macon that held that public funding that is made available to private schools must be available on an equal basis to religious schools. Under every sort of definition of law relevant in the case, charter schools are actually public schools, not private actors. And so the Supreme Court's decision to take up this case was a very alarming sign. They argued the case. How did it end up in a deadlock decision, and what did that mean?
Yeah, so that was just a little bit of luck, I guess, in this case that Judge Amy Coney Barrett recused herself from the case, likely because of her ties to Notre Dame's law clinic that was involved in the case. She doesn't explicitly ever say that. It's not something that judges will tell us why they're recusing from a case, but that's probably a good guess. And that's the only reason why we end up with this 4-4 decision, just way too close. Like you alluded to, this whole thing is ridiculous, from the get-go. The school should never have been accepted by the charter school board. They should have never agreed to charter a private Catholic school that was religious to be a public charter school. Then the Supreme Court rightly struck it down pretty easily. Not really, it was a very obvious decision.
So just like on a process note, the deadlock 4-4 means functionally that the lower court opinion, the Oklahoma Supreme Court's opinion, stands. So basically the whole entire Supreme Court briefing and oral arguments was a giant waste of time, and nothing changes in terms of the state of the law. So the status quo remains. Catholic public charter schools are still a violation of at least the Oklahoma Constitution. We did hear oral arguments on this case. Some of the highlights for me were Justice Sotomayor, who basically captured the whole essence of the argument being advanced in this case, which is, she said, I'm paraphrasing, so basically what you're arguing is there is no establishment clause, right? Like the idea that a state can't charter public schools without letting religious schools also obtain a charter means a state can't have an establishment clause. It can't have public, fully secular public schools. And that's exactly what was being advanced here. Just a further extension of that argument that like anything that is wholly secular is a violation of the free exercise clause, i.e. the establishment clause violates the free exercise clause. So I always appreciate Justice Sotomayor pointing out the inevitable endpoint of this argument that's further and further broadening free exercise rights in this way. But there was a lot of sympathy amongst the conservative justices. Kavanaugh, I think, was especially sympathetic to the idea that this is such unlawful discrimination. It's just like a charter school, just like a Mandarin school or a STEM school can get a public charter. So too should St. Isidore's Catholic School be able to, and anything else is just like rank discrimination. So I think it must have been Roberts who defected, but we'll never know. But again, there's 4 votes to overturn this decision and say that not only is it okay to have a public charter school be Catholic, it's like demanded by the free exercise clause in any state that operates a charter school scheme. So pretty scary stuff.
Yeah, and as you might have seen though from our press release, we are still at least calling this a victory. It is stemming the tide for now.
Sure.
This is definitely going to come back, as we'll talk about in a second, but it's the best that we could have hoped for. In fact, a lot of us, I did not think we would even get this 4-4. I thought they would overturn it right now.
I thought there were 5 votes for this.
Right. So in that sense, it is a victory. It does buy us some time on this issue for a little while. But even within that victory, as you had alluded to, the person fighting on our side in court was Oklahoma Attorney General Genter Drummond. But even his take on the case was not great. He had a statement that he put out afterwards saying, the Supreme Court decision represents a resounding victory for religious liberty and the foundational principles that have guided our nation since its founding.
Sounds good.
This ruling ensures that Oklahoma taxpayers will not be forced to fund radical Islamic schools while protecting the religious rights of families to choose any school they wish for their children. He said, I have always maintained that we must faithfully uphold the Constitution, even when it requires us to make difficult decisions. I will continue upholding the law, protecting our Christian values, and defending religious liberty regardless of how difficult the battle may be.
Yikes.
So this is ostensibly the good guy in this fight, saying that the purpose of this was to stop radical Islam schools, which I don't know, St. Isidore, the Catholic school, I don't know that is a radical Islam. I don't know what they teach there. But
he's not wrong in that a decision in St. Isidore's favor is certainly a decision that opens the door to all religious schools being able to obtain public school charters, just like the funding cases do the same thing. Yeah. But of course, that's the spin being put on it by the Oklahoma AG, and I guess the charitable interpretation is he's responding to lots of backlash he received for daring to fight to uphold the Establishment Clause principles in his state.
Yeah, and I'll just make clear for people who don't recall from our previous discussions about this, a very interesting person because honestly he's terrible on most issues that the way I view things, the way FFRF does, except for some reason the separation of church and state he gets right.
Well, now we know why.
But as you see, he only does that because he wants to make sure Christianity isn't getting pushed down by the Muslims. It seems to be his take on that.
I mean, again, he's not wrong in that the Establishment Clause protects all religionists from...
He is wrong about upholding the Christian values of Oklahoma people because they're not all Christian, as we note, and the government and him in his government position should not be pushing for Christianity to have any sort of special exemptions and stuff. That's the whole point of this case in the first place, is saying that you don't get to mix religion and non-religion. We're not going to pay for your religious school. We'll pay for secular schools that teach people non-religious subjects or don't get involved in that realm.
Yes, exactly. So, yes, the Establishment Clause in Oklahoma lives to die another day. And of course, like, tremendous pushback. It's a very conservative state government. Governor Kevin Stitt issued a statement. This 4-4 tie is a non-decision. Now we're in overtime. There will be another case just like this one, and Justice Barrett will break the tie. This is far from a settled issue. We're going to keep fighting for parents' rights to instill their values in their children and against religious discrimination. Again, that's a weird description of a case that involves what gets to be a public school, but okay.
So as Stitt alluded to, we don't know where or when, but inevitably another charter school and a charter school board is going to try this again. They're going to go before the Supreme Court and try to get Amy Coney Barrett to not recuse herself and to get a 5-4 decision saying that essentially the Establishment Clause is no more. You can't not fund religious schools because they're religious. I mean, as you noted, this has been built on for a long time. Sonia Sotomayor, in her dissents, has been doing a great job cataloging this and calling it out and saying, what you are doing is trying to flip the entire dynamic.
Yes.
And say, rather than, oh, our Constitution requires a religiously neutral government and religiously neutral schools, that religious neutrality is discrimination against religious groups, and that the free exercise not only trumps the Establishment Clause, but completely engulfs it, and free exercise is all that matters. Religions cannot be in any way excluded from having all the government funding they want with no restrictions and things like that. And that's going to come up in our next case too.
And I mean, that's exactly the project as what you're describing. So, and one more note I'll just say about how it's a good outcome that this issue lives to be fought another day. However, it is important to like explain that in terms of like future cases that will come up, the issue in this case that's now left unsettled is not, it's important, this is not funding, public funding to a private religious entity. These are not private religious schools. This is not about funding, right? Like Oklahoma is extremely conservative state government. They fund private school vouchers that greatly benefit religious and parochial schools. They fund scholarship programs that do the same thing. There's no shortage of availability of public funding to private religious schools. This seeks to expand that ever further in granting a public charter to a private religious school. That means it will be chartered as a public school, and it's important because why is this issue not gonna die? I think it's 46 states and the federal government, by the way, define charter schools as public schools. They're public entities. They're not, the Mandarin school and the STEM school that, Kavanaugh's so defensive about. They're not private schools that are getting public money. They are being chartered as a public school. They're a creature of the state, as came up in oral arguments. And so that's really important because that is a big step in a different direction, and it implicates 46 states, how they choose to define their public charter schools. So I think Chris is right. This is not going away. There's probably a test case being, put into place as we speak.
They're attacking us on so many different fronts. In our public schools, they're trying to push more and more religion into the schools. Those are the type of violations that we're dealing with all the time. Teachers, administrators, including prayer, including religious messaging, things like that in our actual public schools.
Right.
This type of case where they're trying to say, actually, let's go ahead and turn a Catholic school into a public charter school and give them our money to do that. And then the third one that you mentioned is the vouchers, where they're saying,
let's siphon all the money out of public schools.
Yeah. Let's take it out of public schools and give it to mostly private religious schools. So it's just like this three-pronged attack. Every venue, they're just either infusing religion, moving money around to benefit religion, and it really is just hurting our secular public schools. And we're obviously going to keep fighting on that and keep updating everyone on how that's going and what happens in this arena.
That's right. All right, now on to the second case we're going to talk about today. And unfortunately, this one had was decisive and it did not go our way. The Supreme Court issued an unanimous decision, doesn't happen often, exempting a group of Catholic affiliated nonprofits from Wisconsin, here in our home state, from the state's unemployment insurance program. This case, probably if you've heard of it referred to as the Catholic Charities case. Chris, why don't you give a little background on this case? What's this case about?
Yeah, so it has to do with religious exemptions for unemployment, from the unemployment program. This case actually, if you really want to go back on it, and this was brought up in a couple of the different parts of the opinion, starts in like 1932, when
Yes.
Wisconsin was actually the first state to have an unemployment insurance program,
Right.
beating the federal government by a few years during the Great Depression. That program, I understand, is that it actually failed because they couldn't get enough people in it. So that kind of relates to this because as with the federal program, and then Wisconsin later adopted it, the federal program put in a provision saying that, like, if you are a religious group controlled by a church primarily for and operating primarily for religious purpose, you are exempt from this unemployment. That was first put in the federal law, and then Wisconsin adopted the exact same language into our law. And it's pretty clear what's meant from that is that
Is
they're
it
saying,
though?
well, not anymore. But it seems clear to me that what was intended, and if you look back at the history, they were just saying, like, yeah, like a small church or a church, things deeply involving the sacred matters of a church, we don't want to necessarily force them to be involved in this unemployment, because then what if we have to come in and say, oh, was this person fired because they weren't adhering to the tenets of the church? You fired your pastor because they weren't following what
Right. Right. In actual churches, like actual like ministry type
ministerial type
or
stuff.
organizations, organizations that are employers, but they engage in like religious training, that type of thing, like operated primarily for religious purposes was sort of the language at issue
Right.
in the case. And importantly, we know it wasn't that confusing to interpret and put into practice, because for decades on decades on decades, everywhere, including in the state of Wisconsin, the Catholic Charities organizations paid into the state unemployment system without incident.
Right, so it's structured in such a way where it's related to the Catholic diocese, but it is a separate nonprofit entity, Catholic Charities, that filed tax paperwork as a charity, not as a religious group, as a charity, and like you said, was participating in the Wisconsin unemployment thing until 2016, I believe, where they then asked for an exemption, saying, hey, we're religious, we should get out of it. They got that, or they won their first thing. It was then overturned by the board, went to the Wisconsin Supreme Court that agreed that it was not, basically that it was not operating primarily for a religious purpose. That,
Right.
like, you're doing secular charitable work,
Right.
helping people, feeding the needy, things like that, that what you're doing is not religious, it's not religiously motivated, was the way that it was probably not helpfully framed. And then they obviously now appealed to the Supreme Court saying basically, hey, this is violating our religious freedom rights by saying that we're not, the way that it was framed by the other side was adequately religious enough
Right.
to sort of be a part of religious exemption. And it was very cleverly marketed in sort of the news of, like, is Catholic Charities not Catholic? You know, like, oh, are you trying to imply that a group called Catholic Charities that helps people that's not a religious
Right.
group?
Wisconsin Supreme Court says Catholic charity not religious enough,
Right.
to meet the requirements of state law. But of course, that's all nonsense, because Catholic Charities, and it's important to actually like describe what Chris is describing, which is this is a huge charity umbrella, almost like United Way. Like, it's massive. It has not only that it starts, but it absorbs secular small nonprofits that do different charitable works. So oftentimes there will be a charitable organization that Catholic Charities owns and operates that you wouldn't be able to even tell from the name of the charity. I don't have it in front of me, but in this case, it involved several charitable subsidiaries of Catholic Charities with names that are, not Catholic Charities. And they do purely secular charitable works, like like vocational rehab type stuff, workforce reentry and training type of stuff, like things that are totally kind of secular employment type of charities operating in the community. Like, we're not just talking about like Mother Teresa's orphanage kind of thing, which we could also argue over whether or not that's operated for religious purposes. But what Catholic Charities was advancing was this argument that anything that we say is motivated by our religion should automatically be exempt. Like that is the analysis, that is the only analysis that the court should use, and like the Wisconsin Supreme Court violated our rights and discriminated against us by finding that our religious motivation was not enough, or that our motivation was not religious. So this case got a hearing at oral argument. We listened and could kind of, you could kind of see a few scenarios that could have played out, although I was very shocked to see a unanimous decision. I do think it was clear that Catholic Charities kind of had the votes for some version of this. I think the most charitable thing we could say about the unanimous decision is that it was sort of the narrowest version of a decision in Catholic Charities' favor that you could have probably seen put together. So what are the implications? Like, what does it actually mean? What did the court do?
As we kind of alluded to in our amicus brief that we filed, in this case, our real concern, besides the specifics here of the Catholic Charities, is that there's just a lot of organizations, secular organizations, under the Catholic umbrella. A lot of hospitals in Wisconsin, things like that. You're talking about, I saw numbers as high as like 1.5 to 2 million people employees who might now potentially be exempted from these things under this idea that if you
nightmare
work with
for
the Catholic,
workers.
Right, which definitely undermines the social safety net of the unemployment program, but also just really, as I kind of alluded to when we first started talking about this, defeats the purpose. It defeats the purpose of what this exemption was for, which is just for that sort of church-related stuff, not any remotely church-related organization, no matter what they do. So, yeah, it's like you said, it's a narrow decision, luckily, so that hopefully will mean that we aren't going to see the worst of it, that other groups could maybe be distinguished in different ways, or that they wouldn't rule that like every nurse working in a Catholic affiliated hospital is now exempt from unemployment, but that still remains to be seen.
So I want to just do a quick explanation of what they did seize on in the opinion. So this came up at oral arguments, and it was one of these things that's very typical of the Supreme Court. When you're reading briefs and like the decisions below, you really get a sense for how like narrow-minded and like myopic the view that the Supreme Court justices take on these cases, and it can be really frustrating. So they seized on this sort of finding, I guess, and honestly just like discussion from hypotheticals in oral argument that one of the things that the state of Wisconsin would use, or I guess put forth as an example of what would be indicative of whether something was operated for primarily religious purposes would be, do they only serve co-religionists, like a soup kitchen that's only for Catholics, i.e., to me that means it operates out of the literal Catholic Church, like it's for Catholics. It's or we proselytize, or we make our charity conditioned on proselytizing, or we only you don't get your food until after you say a prayer, or you don't this orphanage is only for kids who accept Jesus Christ as their personal savior. So like drawing those I don't think that the court's opinion in Wisconsin literally hinged on like those distinctions, especially in the Catholic charity. Like there's no factual basis, I think, for like, well, in Wisconsin, this this other charity exists and they do vocational training, and the only difference between them and this Catholic Charities subsidiary is these guys serve co-religionists and Catholic Charities don't, and that's why they were denied the exemption. Like, that's not factually true.
Right.
But the court seized on that sort of illustration given by the state as interdenominational discrimination. And if we say that the Wisconsin Supreme Court is engaged in denominational discrimination, so between how different religions would run their charity, like on theological questions, then we have to review this with strict scrutiny, which is a standard of review that's very hard to survive in terms of the government's action or the decision below, which is exactly what they did, and said, no, the Supreme Court didn't survive. There was denominational discrimination. You didn't survive strict scrutiny, and therefore we're going to reverse the decision and send it back to the court below to somehow put this decision into practice as they rehear the case. So that came up at oral arguments, the idea that if we find that there's denominational, they seized on those hypos, those distinctions in like how, whether you serve co-religionists or whether you proselytize it while you do charity. And because Catholic Charities so magnanimously doesn't do either of those things, they're just like being discriminated against and can't not pay unemployment taxes. Even Sotomayor sort of alluded to, okay, if we find denominational discrimination here, then we move on to strict scrutiny. Do you survive strict scrutiny, state? So she did allude to, I guess, an openness to that argument, and that was the narrowest way to decide the case in Catholic Charities' favor, and that's exactly what we saw, and unanimously saw.
Right, like you said, I think the problem was just with the framing, and I get it because it's like, Wisconsin's job basically would have to be is like, how do you articulate whether something is primarily religious or not?
Right.
And that's how we end up with this proselytizing, serving co-religious. Is like, how do you, I think for most of us, at least the way I feel, is sort of a vibe. I mean, there's no, like what is the, primarily religious?
Right.
And obviously Catholic Charities' view was, oh, we help people. That's religious to us. If we're helping people, that's just being
or we do it because we're serving Jesus.
Right, we're motivated, because of our Catholicism to do this. Whereas they were looking at other aspects, which I think are closer. I don't necessarily like the framing, but it's like, right, you could tell, like a church is religious. People are there talking about doctrine, they're praying, they're worshiping, like that's clearly religious. Well, then you go over to like a secular organization and you're like, okay, well, nobody here's praying together.
I don't even know
prayer.
I'm in a charitable, or I don't even know I'm in a Catholic charity. I just walked into the vocational rehab center of such and such place.
They don't mention God, they don't proselytize to you, they don't do whatever. And obviously, the issue is we don't want to encourage people to proselytize.
Yes.
So that would not have been a great solution here either if Catholic Charities.
That's the right way to run your
exactly.
charity.
So we don't want the solution to have been Catholic Charities going, oh, okay, well, we'll start proselytizing and we will stop helping people who aren't Catholic. So obviously that's not a solution. So I think that's part of the bind that they found themselves in because they didn't want that to be the result. So like, okay, I guess what we have to do is just let Catholic Charities into this exemption and say Wisconsin violated their rights and differentiated in this way.
So you're probably thinking, so what is the law? And I think that's an open question, right? Like this did not clarify much, and it's going to lead to a lot more litigation on who's eligible for this exemption, including even under this decision, going back for a remand to the lower courts, is the Catholic Charity subsidiaries in this case even eligible for the exemption? I mean, it probably won't be settled by these parties because the history of this case has already happened, and that remains to be seen what the state of Wisconsin will do with this exemption. But arguably, it was a failure in the application of the exemption, not that the exemption itself is in some way, like facially unconstitutional. And so Justice Jackson proposed in a concurrence, which means this was not the opinion of the court, but proposed a sort of a formula that would have not resulted in this discrimination based on theological choices like the proselytizing, but would have yielded the narrow result that I think we would advocate, which is that this is a narrow exemption. The way it's written Clearly, the legislature did not mean for it to be eligibility to be any religiously motivated charitable organization in the entire state. So that means it's narrow, and that means we're looking at religious purposes, even though the dictionary definition of purposes could mean intent, and it could mean, what Justice Jackson called the how and the why. What it really is getting at is the what. Right. What does the charity do? What is the actual purpose of the charity? Not the intent of the people doing the charity, but the purpose of the charity itself. The what. What does it do? Vocational rehab? Serve food? Shelter orphans? Does it do job interview training? Does it do, some sort of just secular charitable purpose? It is not entitled to the exemption. That is what is being analyzed. That's a great framework. I don't know if the clearly that didn't have majority support.
Yeah, and she did a good job breaking down why this is the logical conclusion to reach, including the most persuasive thing I think is that, as we can allude to, it's a two-part test or a two-part
in the statute.
In the statute, there's two parts to it. One being, are you primarily
operated for religious purposes?
And then two, are you associated with a church or association of churches? Are you church affiliated, basically?
Yes.
And she points out, and I think this is a good argument, that if primarily religious means religious motivation, then these two parts are redundant.
Yes.
Because you're already saying that it's associated with the church, which would mean it would be religiously motivated, particularly under Catholic Charities' point of view. So it's then this primarily religious purpose
would be superfluous, and that would make no sense.
Yeah. And she goes back to the history of when the original federal law was created and some of the legislative analysis with other documents they were talking about at that time, and points out that this clearly was for church training, we're training churches and things like that.
Yes. So definitely not the way that the Freedom from Religion Foundation would have preferred this question to come out, right? There is no world where Catholic charities should be exempt from unemployment insurance tax under the statute, the state statutes of Wisconsin, like Chris just pointed out. And so a unanimous opinion basically saying, oh, well, there was discrimination here in the way that the court interpreted it, right? It's kind of in the flavor of Masterpiece Cake Shop, right? It's a big process win for these, religious far-right litigants who are trying to explode a tax provision or just grossly expand an exemption from the law, or undermine a tax or insurance or Social Security safety net system to the detriment of everybody else, including their own employees, right? The losers of this case are workers, tens of thousands of workers who work for religiously affiliated nonprofits that do secular work, like Chris said, hospitals, universities, big giant charitable endeavors that employ tens of thousands of people, like Catholic Charities itself. They do legal clinics. They do they employ tens of thousands of non-Catholic, just secular employees doing secular work. Are they going to be are they going to be eligible for unemployment?
As we pointed out in her press release, the only
redeeming
tiny silver lining, if you did the thinnest of silver linings, is that because the decision was written by Sotomayor,
it was as narrow as it could have been, and they were going to win anyway, given the supermajority.
So I was just going to mention that she did reaffirm the Establishment. She mentions the Establishment Clause explicitly, and that the Establishment Clause protects from the government distinguishing between religion and religion.
Yes.
So reaffirming the Establishment Clause is the thing, which is important to do now as we're seeing from these cases.
Got 9 justices to sign on to that is no small. Nothing.
Right.
Yes.
So that is something, being able to put that in there. That is the benefit of having her write this as opposed to one of the right-wing conservative justices who does not actually believe the Establishment Clause has any power.
There was no world in which, given the makeup of the Supreme Court, Catholic Charities did not have the votes to win, and therefore the narrowest possible win is better than every possible alternative that realistically existed. But of course, this opinion like does nothing to advance like either free exercise or workers' rights or the Establishment Clause. It only will create more confusion, more religious privilege at the expense of workers.
Right. This is just another chipping away at the Establishment Clause in favor of religious privilege. That's just expanding and expanding. Anywhere where we've had the tiniest little cutout where we said it makes a little bit of sense reasonably to not have a church be engaged in this, they're now breaking that open and saying religion gets to not only take advantage of all these exemptions, but they get to dictate the terms under which they qualify and things like that. So it's very alarming, but obviously we at FFRF are going to keep fighting on these things. We're going to keep getting involved in these cases. We're taking our own cases on the other side to defend the Establishment Clause, and we're doing everything we can to push back against this, this current court.
Yeah. So before we wrap up, I'm just going to, these are kind of comments, kind of questions, but I'm just going to throw them out there and see what you think. Chris, we got one comment that's basically, I should be able to claim tax exemption for my non-religious beliefs / religious beliefs. Like, why should I have to contribute to any of this? Like, I think what this commenter is getting at is something that I think is really like the crux of what's wrong with the Supreme Court's just fetishization of the Free Exercise Clause and subordination of the Establishment Clause, which is ultimately it discriminates and makes like second-class citizens of the non-religious or the people who are motivated morally by supernatural, non-religious values, right? Like humanists.
Yeah.
Because again, like it's this, even in Catholic Charities with this narrow decision, right? The discrimination being recognized is between religious denominations and theological preferences. And like, there's no acknowledgement of the fact that like non-religious Americans are also like part of, or also deserve religious liberty under the First Amendment. And like, that's what makes the Establishment Clause equally important to the Free Exercise Clause.
Yeah. Well, related to that, I'll say that that's one thing that comes up in this case is a little bit different from some of the other religious exemption cases. We get a lot whenever a religious group's given some big exemption or a carve-out is ripped open into this big thing, people will be like, oh, now the Satanic Temple can do this.
Right.
And now that they'll kind of like this sort of thing. Well, in this case, that doesn't really work. I actually saw that on a couple different comments specifically about this case.
Yeah.
Because the problem is, we don't want everybody to stop paying into the unemployment system and have it crash and not be able to work for all of us. We want more people to be participating. We want more workers to be protected by it.
Right.
So it's not a situation where you can say, oh, maybe some Satanic Temple branch in Wisconsin can now stop giving unemployment insurance to their people. That's actually really bad and not a solution.
Right.
So this is not a case where we're all going to take advantage of these exemptions.
And like this is really an important point, Chris. I want to riff on this for a second because like this is what is so warped about the way the court has decided to treat the Free Exercise Clause in its, in the past couple of decades. It's that it doesn't allow for any. So the Free Exercise Clause, as many FFRFers have pointed out over the years, the Free Exercise Clause, the First Amendment, right, the religion clauses, Congress shall make no establishment of religion nor prohibit the free exercise thereof, right? Prohibit. That is a choice. It doesn't say burden. It doesn't say in any way affect. It says prohibit. So the idea is that we as a society can make decisions that certain things, certain state interests are so important that even if they burden religious exercise, we're going to tolerate that because it's so important to have a unity in our policy over this thing. So a great example of that is our our civil rights laws, right? Our anti-discrimination laws. Like we made a decision in the 60s that like we need laws on the books that prohibit discrimination in places of public accommodation, in housing, in employment. And like that is so important and it's been so pervasive, and we are acknowledging as a society that this is like an utmost state interest, that we're gonna minimize exemptions. We want as few exemptions as possible, only what's absolutely necessary, even if it's burdensome, even if it's religiously burdensome. It's okay. We're not prohibiting the exercise of your religion by saying you have to pay a tax or you have to serve people who are different than you. We might be burdening it, but we're not prohibiting it, and that is okay. And that is what is being absolutely like eviscerated case by case as the Supreme Court further expands the importance of the free exercise clause over every like public policy scheme that we have put in place to serve greater state interests.
I mean, I think what you're alluding to is we're moving closer and closer to potentially like overturning Employment Division v. Smith, which said basically we can have generally applicable laws that apply to everyone.
What I just said, basically.
Yep, exactly. Yep. Generally applicable laws. They're not targeting religion. They're religiously neutral. They don't care whether you're religious or not. You know, you follow the speed limit. We don't care whether you're Catholic and you speed or you're non-religious.
It's neutral.
It's just a neutral law, and they potentially could overturn that. That's what they're moving towards, just breaking this down to the point where someday that might happen is like, well, we Catholics, we like going really fast.
Jesus took the wheel.
Yeah, Jesus took the wheel. We believe that we can drive over the speed limit and you can't impose this law. That's obviously an exaggeration, but that's the type of thing we're talking about. Laws where it's like, this is just common sense for everyone. We don't care about your religion, not in a mean way, not in a derogatory way.
And the way the court would express that is that would go to the standard of review.
Right.
It's not strict scrutiny. It's just that the state has to advance some interest. Like, why are we regulating this? If it burdens your religion, fine. Jesus took the wheel. Why are we regulating speed? Oh, we have a compelling state interest? Fine. That's enough. That was the scheme under Smith. That has been the sane, secular scheme that is in keeping with both clauses of the religion clauses of the First Amendment, up until this recent, supermajority Christian nationalist court. And now all of a sudden, everything is up for grabs and religion is a get out of jail free card. Just want to say again that we have other decisions we're waiting for from the Supreme Court. We're still in the middle of their decision season, and you can hear us cover the remaining 3 decisions that we're watching right here. That wraps up this week's episode of FFRF's Ask an Atheist. You can also check out our other show, Free Thought Radio, at ffrf.org/radio or wherever you get your podcasts. Be sure to check out the latest episode of We Dissent. It's the only podcast hosted exclusively by women constitutional lawyers, including me, discussing state church separation. Listen and subscribe to We Dissent wherever you get your podcasts, or check us out online at we-dissent.org.
We also have a lot of fun and irreverent merch available on our online store. There's t-shirts, bumper stickers, pins, coffee mugs, books, and so much more. You can check all that out by visiting ffrf.org/shop.
Finally, if you want more information about the Freedom from Religion Foundation, check out our website at ffrf.org. If you're a member already, thank you. And if not, please join us. We will see you next time on FFRF's Ask an Atheist.